Last Monday, The New York Times reported that at least 6 members of President Trump's White House team used private email accounts to discuss government business. According to the Times and a separate report by Politico this week, the president's son-in-law and advisor Jared Kushner, along with daughter and advisor Ivanka Trump, former chief strategist Stephen Bannon, former chief of staff Reince Priebus, and advisors Stephen Miller and Gary Cohn, used personal email accounts to conduct White House business. Hillary Clinton called this the height of hypocrisy, since Trump spent much of his campaign calling for her to be locked up for her use of a private email server while serving as Secretary of State. But is it actually illegal for White House staffers to use private email to conduct government work? I reached out to 7 legal experts and asked for clarification. Most agree that we don't know enough to draw any definitive conclusions. But former federal prosecutor Renato Mariotti told me it could be a violation of a non-criminal law called the Presidential Records Act unless they forwarded all of the private emails to their public accounts within 20 days. That 20-day mark will become extremely significant if the reports are proven accurate. If private email correspondence was forwarded to public accounts within this window, there is virtually no chance of criminal charges. If not, everyone above could face legal issues. Another potential crime has to do with the sharing of classified information. According to Lisa Kern-Griffin, a law professor at Duke University, if classified information was transmitted over personal accounts, that may have compromised national security. Since we don't yet know what was discussed on these private emails, this remains an open question. Nearly all the experts agreed on at least one non-legal point: if there were a law against hypocrisy, the Trump administration would be guilty 100 times over. And while that may not result in legal issues, it ought to be a political problem for an administration already awash in scandals. The 7 legal experts' full responses, edited for clarity and style, are below. Renato Mariotti, former federal prosecutor, 2007-16. While it's ironic that White House officials are using private email accounts for official business, given Trump's calls to lock up Hillary Clinton for her use of a private server, their use of private email is almost certainly not a crime. But it is a violation of a non-criminal law called the Presidential Records Act unless they forwarded all of the private emails to their public accounts within 20 days. In addition, there are rules requiring government employees to encrypt for official use only information when sending it via email. Violating the Presidential Records Act or these rules would likely result in discipline or termination, depending on the seriousness of the infraction. Lisa Kern-Griffin, law professor, Duke University. In the firestorm of profiteering, norm-violating, and potential criminality that characterizes the Trump administration, the private email accounts may be yet another story that is quickly forgotten. But whether or not the emails create new legal issues, they should be a political problem. Hillary Clinton's allegedly corrupt use of private email was a flashpoint throughout the campaign, and President Trump continues to whip his supporters into chants of lock her up even though the FBI investigation is closed. That Jared Kushner and Ivanka Trump set up a private domain of their own during the transition reaches new heights of hypocrisy, arrogance, and above-the-lawism. As for whether use of their private accounts violated the law, that remains to be seen. If government-related correspondence was not copied and retained, that would be a violation of the Presidential Records Act. If classified information was transmitted over personal accounts, that may have compromised national security. White House aides who used their private email were certainly foolish and were also flouting express warnings from the National Security Agency about breaches by foreign intelligence. It is also possible that this forms part of a pattern of concealing communications with the Russians, a pattern in which the Senate Intelligence Committee and Special Counsel Robert Mueller are clearly interested and which may help prove an intent to obstruct. The issue here is really one of irony and hypocrisy more than illegality. Jessica Levinson, Loyola Law School. Andy Wright, law professor, Savannah Law School. All the Trump White House staff who have communicated on non-official devices over 20 days ago without forwarding them to an archived account have violated the law. The Presidential Records Act requires that almost all communications with White House staff on official matters need to be preserved. The Act, 44 U.S.C. Chapter 22, requires that records demonstrating the activities, deliberations,